You're watching Behind the Headlines. I'm Pacchia. When the financial regulatory reform bill known as Dodd-Frank was passed way back in 2010, there was a little notice rule dealing with swaps buried in that massive overhaul. The obscure provision known as the Lincoln Amendment was openly acknowledged as a mistake by members of Congress, and promises were made to fix the rule. But if you've been following Congress as of late, it should come as no surprise that it didn't get fixed. And now it's a problem. Joining us now to walk us through the issue, we have Scott Cammarn. He's a partner at Cadwalader, Wickersham and Taft. We're very happy to have him back on the show.
Thanks, Lee.
Welcome.
Good to be here.
This amendment has you worked up. What is in the Lincoln Amendment?
What the Lincoln Amendment says is that entities such as banks or U.S. branches of foreign banks that either have access to the window or have FDIC insurance can't be a swaps entity, which means basically a swap dealer. So what it requires is that banks and U.S. branches of foreign banks push out their swaps business into another entity, or in the case of foreign branches, they can't. U.S. branches, they can't access the Fed window. It requires the banks to separate the swaps business from the banking business.
And being cut off from access to the Fed window is problematic because in times of economic crisis, it's the lender of last resort.
That's exactly right. If you look at what happened in 2008 and 2009, there's a tremendous spike, and the Fed window is the lender of last resort for financial institutions, and it's important that it's there.
U.S. branches of foreign banks could be in trouble if the amendment passes and goes into effect as it's written. Why exactly?
Well, there's a couple issues. One is, to begin with, the U.S. branches of foreign banks are actually substantial players in the U.S. markets. They make up about 15% of U.S. banking assets, so they're by no means not a small part of the U.S. system. What the Lincoln Amendment says is that banks have to push out these activities by July of 2013. Now, due to an amendment that was added in the conference committee, certain relief was given to insured depository institutions, giving them greater time to push out the activities, and also creating exemptions for certain types of swaps, such as rate swaps and currency swaps. Because of that language, though, insured depository institutions, there's some fear that that language doesn't apply to U.S. branches of foreign banks because they're not FDIC insured. That would mean that the U.S. branches of foreign banks need to push out their swap activities this summer, much sooner than with respect to U.S. banks that exist here. The other issue, of course, is that there are exemptions that are available to U.S. banks, rate swaps, currency swaps, and the like, that the U.S. banks can keep. The U.S. branches of the foreign banks, they couldn't keep those. They would have to push those out as well. And that's problematic. The U.S. branches of foreign banks are being treated very differently than the U.S. banks are.
And that's a large sector of the financial industry. How did an amendment like this make it through the Congress? It's being called or acknowledged as a mistake by Senator Blanche Lincoln, the senator for which this part of the bill is named.
Right. It's a very interesting story. This provision wasn't in the House bill that passed in late 2009. It wasn't in the original Senate bill that Senator Dodd proposed. It was added after the fact. It came out of the Ag Committee. It was objected to by all of the regulators because they felt that it wasn't necessary, that swaps weren't viewed as being a cause of the crisis. And then in some ways it was counterproductive in the sense that pushing swaps out of banks might not necessarily be in their best interest. It makes them harder to resolve a bank. And frankly, swaps do some good things. They hedge risk and they otherwise reduce the risk that the banks have when they operate with customers. So pushing these swaps out wasn't necessarily viewed as a good thing. It was a rather controversial provision.
Fixing this can't be easy, though. Congress would need to legislate, and they're not exactly on top of their game these days.
Well, maybe. The concern is that insured depository institution isn't defined, and maybe there's some way to interpret that phrase to include U.S. branches of foreign banks. I think that's a difficult argument.
Yeah, I'm sure the foreign banks don't want to find out in court what the interpretation should be.
And they have between now and July to address this. So the hope would be that Congress would honor the statements that they made on the floor of the Senate and actually introduce some corrective legislation to fix this problem, which everybody admits is a problem. Senator Dodd and Senator Lincoln both acknowledged that there was no intent to treat U.S. branches of foreign banks different than U.S. banks themselves.
Do we have any indications at this point as to how regulators are going to view this part of Dodd-Frank? Are they going to enforce it as it's written?
The most recent indication, at least publicly from the regulators, is a release that came out from the OCC just last week, where it allows banks to petition for an extension. Now, this is part of these relief provisions that were added in conference. It allows insured depository institutions to apply for an extension for up to 2 years until 2015. Notably, the OCC didn't specifically allow U.S. branches of foreign banks to apply for this. So the concern is that the OCC is indicating that it doesn't believe that these provisions, these relief provisions, are available to U.S. branches of foreign banks.
Despite what's being said publicly about this amendment, however, it strikes me that this seems to benefit American banks at a time when American banks, quite frankly, could use the help. Is it possible that the federal government wants this amendment out there in order to protect an American industry?
I really don't think that the U.S. government has any interest in seeing it pass in this fashion. The idea behind the Lincoln Amendment was to protect the federal safety net from the risk of swaps activities, and therefore not let swaps be something that would allow some type of claim against the Federal Deposit Insurance System or against the Fed window. The reality, though, is that this safety net is important, just as important to U.S. branches of foreign banks as it is to U.S. banks themselves. Those branches have access to the window by design. They're an important part of the U.S. system. They have access to the Fed window. If we have another financial crisis, they need to have this liquidity because we don't want them going down because they will impact the U.S. banks themselves.
It'll have a systemic impact. Right. So if it comes to pass that the United States government treats U.S. branches of foreign banks differently in its own backyard, if that scenario plays out, what's the global effect? Are other countries going to follow suit, and is there a concern that reprisals might be an issue?
Well, I think this is just one more thing we're seeing about Dodd-Frank that is raising concerns abroad. You see the Volcker Rule, which impacts foreign banks in ways that were never intended. And you see the prudential regulations that came out that had significant burdens on U.S. branches of foreign banks and their U.S. subsidiaries. This would just be one more thing, in addition, for example, to the swaps regulation that apparently will be applying abroad, that are raising concerns by foreign regulators that U.S. law is now extending beyond the borders of the United States and impacting their banks in ways that's not competitively fair. So it will raise the concern among the foreign regulators that this is just one more thing that they have to deal with U.S. banking law.
So when we're talking about this issue today in early January 2013, about a regulation that's going to come online presumptively in June of 2013, right. Two adjectives that jump out at me are late and uncertain. What on earth do you tell a foreign bank so late in this process? They need to be doing something at this point, right? They can't just wait.
They need to be planning for the likelihood, or the possibility at least, that in July they will need to push out their swaps business into other entities.
How much does something like that cost?
Well, for the branches of foreign banks, what they would likely do is simply have that swaps business be booked into their home office and have the home office become the swap dealer. So they would move the activity out of the branch and into the foreign office. The disruption is really on the clients because the clients are used to dealing with the U.S. branch. Now they have to deal with another entity, the home office abroad, and those swaps will be treated differently because they're not in the U.S., they're cross-border swaps. So it raises concerns with forcing customers to do business with home offices rather than U.S. branches.
Scott, thank you so much for stopping by today.
It's a pleasure. Thank you.
That's Scott Cammarn, partner at Cadwalader. If you'd like to learn more about the cases and issues we just discussed, be sure to go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Pacchia. Thanks for watching.